Okay, this is Public Hospital District Number 4, King County Board of Commissioners. It is our work study time. It is Wednesday, February 27th, 2019. We are starting at 7:21 instead of 7 p.m., which is a change in time. And we now have an agenda here. We are not going to, even though we're starting a new meeting, I don't think we need to do the flag salute over unless somebody is really compelled to do so.
No, I just.
Okay, and the roll call, I think, is the same. Do we have to do roll call? Skip, where's Skip? Do we have to do roll call?
You do not have to do a roll call.
Okay, so hearing that, we're going to move on to the reading of the special meeting notice, whatever that is, and, which I think I pretty much did. Approval of the agenda. Do I have a motion?
You should approve your agenda, and at that time when you approve your agenda, you can acknowledge that the commissioners are here, because there are two separate recordings.
Yes.
And so you would acknowledge that you have
So
a
we'll do a roll
quorum
call.
and that all commissioners. So you can either do it by roll call, or you just could put it in your minutes to reflect that.
Okay.
I make a motion to approve the agenda.
Second.
Is there any discussion? Hearing none, we'll vote. All those in favor, say aye.
Aye.
Opposed? Okay, there is no opposing. And I will say just for the record that we are starting at 7:22 and all members are here.
Thank you.
And we will turn it over to our legal counsel.
And thank you, Madam Chair and Commissioners, and thank you, Dr. Whitcop, your CEO, and your CFO, Steve Daniel, for inviting me and giving me the opportunity to update on Public Records Act in the state of Washington. And first we're going to talk about public records now and into the future. It reminds me what Yogi Berra says. He said that the future ain't what it used to be. Well, that's true, and things do continue to change. So we are going to talk about the changes. Here's the first question of the night. I've already told Commissioner Young that I'm going to pick on her, to ask her questions, keep her awake. How many years now has the Public Records Act been in place in the state of Washington? Any guesses?
I'm going to make a guess.
Yeah,
45 years?
very close, 47 years, adopted in 1972.
Oh,
So
this
the-
is 71. Oh, okay.
Sherman's been doing her homework. So we're going to talk about how it's evolved, and more importantly, we're going to talk about how it affects and impacts you as a Board of Commissioners, and specifically a public agency who has duties and obligations. And Commissioner Pollard says, well, I want to make sure that when we talk about this tonight, we know what the statute is. He wants to know, where does this come from? So he asked, are you going to tell us about the RCW? The very first slide, and I did not prompt this question from him, the very first slide says it comes from the RCW, Revised Code of Washington, Title 42, 56. It gives you the statutory framework.
I started to look that up on my computer.
Uh-huh.
I was going to print it out. It's 60 pages long.
Yes.
So I could forget that.
What's really interesting is they started out with just a few exceptions or exemptions that were from the Public Records Act, and they're now over 400. There's a Sunshine Committee called the Sunshine Act Committee, and each year they consider more exceptions and exemptions. So it can be quite complicated. There's also a WAC, and that stands for Washington's Administrative Code, and those are model rules on public disclosure, and they provide the practical but non-binding advisory guidance. And there was a case recently that said, yes, those are suggestions, but they're not binding. It was because somebody sued an agency. So the Public Records Act, or what we call the PRA, and you have these handouts, you can follow along, and I'm going to go through them fairly quickly. It says that public records maintained by state and local agencies have to be made available to all members, with narrow statutory exceptions and exemptions. We're going to talk about some of those. So what is a public record? It is defined again in the statute, and it's those 60-plus pages that Commissioner Pollard talked about, but it's any writing that is prepared, owned, used, or retained by any state or local government agency and contains information that relates to the conduct of government or the performance of any governmental or proprietary function. What does that mean? Well, it's broadly defined. It includes not only traditional written records, photos, maps, videos, voicemails, emails, text messages, and tweets now. The WAC says that an agency is not obligated to create a new record, though, to satisfy a records request. So somebody says, I want you to give me a record about how many times Commissioner Spiker objected. Well, if there's no record on that, you don't have to go create one. You don't have to create a new chart that kept track of how many times Commissioner Spiker objected at the meetings. So you don't have to create records, but you have to produce them if they exist. Another case said that the Washington State Supreme Court provided an excellent example that explains the complex question of whether or not you have to create records. It can be very daunting when you get a public records request. It literally could ask for something that would state, I want every email that the Snoqualmie Valley Hospital has ever produced. And you would have to provide that. Now, you might not have to produce it until the year 2037 because it might take it that long to be done.
Can I ask a question?
Yes, absolutely. And I encourage you to ask questions as we go along. Otherwise, we get to the end and you might not remember.
How come, I mean, when I ran for office, for this particular office, I went downtown in Seattle and got all the records. They had it all papered up and I had to pay for it, I had to pay for printing and everything. How come now, when we have staff, they're pulling up emails and pulling out other electronic stuff, how do we reimburse for their time and their effort to have to do that?
Anybody know the answer? You
Other
don't.
than don't?
You can't. Unless you do an actual cost of the paper and the actual cost of the machine, you can't charge for staff time. Staff time is not chargeable or billable to the public records. You can charge for the disk, you can charge for the paper, you can charge for the electronic, you can even probably calculate how much electricity it might take to run the copy machine, but you can't charge for staff time. That's by statute.
Okay.
So the public record exemptions are also found in the RCW. There are numerous other exemptions, though, and disclosure prohibitions that are sprinkled throughout other state and federal laws. And so you can find other exceptions and exemptions, to include HIPAA. Now, HIPAA doesn't specifically appear in the PRA, but it's an exception and exemption. You say, no, we're not going to provide you patient information, PHI. Statutory exemptions must be narrowly applied, and they provide only the basis for withholding public records. Agencies cannot withhold records based on an assertion that the release would cause embarrassment to an agency official or employee. And as a general matter, you cannot withhold records solely upon the identity of the requester. So you can't say just because it would embarrass a commissioner or a staff person or the district, we're not going to disclose it. You have to disclose that. All members of governing bodies and public records officer must complete PRA training. And again, Commissioner Paul and I were talking before the meeting. He says, is that required by statute? Yes, it is. And there's the statute, 42, 56, 150, and 152. Training must be completed within 90 days of taking the oath of office or assuming the duties. So what is the penalty or sanction if you fail to do this? You were taken out and flogged publicly. You were put in stocks. There is no penalty, there is no sanction if you fail to do this. But it's like a number of laws, they tell you this is required, but there's no specific penalty.
No monitoring of it?
And I'm not even sure how it's monitored. You should be able to provide proof if somebody inquires. I guess the state auditor could do a performance audit and look into that. And tonight, thanks to Valerie, she has created some very nice certificates that will show that you attended. I have some certificates that are not very nice that are produced by the Attorney General's office I'm going to give you as well, but they're not nearly as nice as
But I think this is an excellent to be consistent with, because new commissioners, really, they're coming in blind, they really don't know what's going on.
Correct.
So I think this is important.
That was the purpose of the statute. The legislature felt that you should have that within 90 days. So you
Yeah,
understood.
thank you.
Correct. Effective July 23, 2017, the PRA and records retention training for public records officers has to include training on retention, production, disclosure of electronic documents, including updating and improving technology information systems. So that's a picture of Steve Daniel with all the hats on that he wears. And those are the numerous hats. I got to keep track of records and records retention and approval of this, approval of that.
One of the
Is it
titles
one?
that Steve has had is compliance officer.
Yes.
Did he specifically mention that title?
It does not use that in the statute at all.
So
But it-
we more appropriately call him a public records officer.
He is a public records officer. I think he's been designated that by your district. I know he's a compliance officer. In fact, we were on a compliance call, I think, last week. And I remember, and I asked, and I was doing a presentation I says, CFO Daniel, are you there? He says, yes, I'm here. So everywhere I go, he's there. He's got all these different hats on that he's
Did
wearing.
you get a certificate from, as a compliance?
No, it
It's
was
not
on-
required?
It was interesting. The topic was on hospital foundations
I
and
see.
what are the requirements for hospital foundations. So we did not give out any certificates. Training requirements for the public records officers. Here's what's required. And several new PDRA-related assistance programs are available now. So they will give you some public assistance. They will give you some monies. The Attorney General has these. It's a consultation program, and they are doing state archives, records retention training, and they have competitive grant programs to improve information technology, et cetera. So the legislature did set aside a little bit of money to try and help you here. First step to ensuring compliance with the PRA is to adopt a policy. The policy should include the basic procedural requirements, such as identifying the public records officer, we know who that is, outlining the response, the process. And I believe you had that online, Steve, so people know, here's how I can get a record. State and local government agencies are required to respond to a public records request within 5 business days. We call that our 5-day letter. So when a request comes in, you must respond within 5 days. Does not mean you have to provide the records, but you have to respond and acknowledge that it's been received, and you have to give an estimate. You can provide for inspection and copying of it, and you can provide an internet address and link where you can go get the information. You say, we have that already on a link on a website, and it's available. You can go get it. You acknowledge receipt, and you provide a reasonable estimate of the time necessary to respond. Numerous lawsuits as to what is reasonable and necessary. So you document your efforts. It takes into account what your staff is, what your time is, what other essential priorities you have to do. So the courts have been pretty lenient about trying to give you some time to respond. Once you acknowledge it, you can also ask for clarification on the request if it's unclear, and you're supposed to provide, to the greatest extent possible, a reasonable estimate of time necessary. You can deny the request. If a request is denied, a written statement must accompany the denial saying why it's being denied. And most often it's denied because we have no public records that pertain to your request. We don't have any records. Sometimes it's a request for information. They're asking, how did you come to this decision? Or how did you decide to do this or that? Well, that's not a request for an identifiable public record. It's more of your impressions. And so most of my clients that I work with, a lot of public agencies, I view as a request for information. I tell them to respond and say, it appears that you want some information. Could you meet with me? Could I talk to you about this? Would you like to discuss it further? Or maybe you can provide them some information that's not a public record per se. So additional time to respond may be based upon clarifying the intent, locating it, assembling it, notifying third parties or agencies affected by the request. You'll remember that's a situation that this board was in with Astria.
Yeah.
There was a request for public information, and we informed Astria that we were going to provide this information. We were going to disclose it unless they got a protective order. They did, in fact, go get a protective order, and we ended up, as you know, reaching an agreement with the requester for public records as to what he needed and wanted, and determine whether any of the information is exempt or whether denial should be made as to some or all. It requires agencies to perform an adequate search to locate the records. PRA itself doesn't provide detailed provisions on how to conduct it. The WAC that I talked about from the Attorney General's office gives you suggestions. There's numerous cases out there, case law that gives you suggestions. Email sent to or received from an agency's official personal email address are public records if the message discusses any agency business. This is one of the first cases that came out in this area in 2009. So if you have a laptop at home or a tablet or a smartphone and you're sending and receiving information, that is a public record. You have to maintain it now, either there or here in the facility. And if it's a request for an email that you've ever sent to and from, that becomes a public record. So it's a new area of concern because now public records requesters can access your personal computer for these types of records. Now, they can't get your personal information, of course, but they can if it pertains to agency business. So that's where the real trouble comes in, failure to comply with the Public Records Act. If you say, no, I'm not going to provide it, I'm not going to give it to you. A party that prevails against a public agency is awarded costs, including reasonable attorney fees. In addition, it shall be within the discretion of the court to award such a person an amount not to exceed $100 for each day that he or she was denied. So if you have several thousand records that you didn't produce for many days, $100 a day, times each and every record, one court case came down that said just one page could be a record. So if you go through each page and you have thousands of pages, you do the math, it can get very, very expensive. Any per diem penalty, which is the amount per day imposed for an agency's refusal, must be assessed for each day that the records were wrongfully withheld. Trial court discretion lies in the amount per day penalty, so it can be up to $1 or $100 a day. In determining the per day penalty, they would look at mitigating factors, lack of clarity, the agency's prompt response, you were trying to follow up, you had good faith, honest, timely, and making really a good faith effort. And you can't be held personally liable, if you're making a good faith effort. Individuals like Steve's not going to be held personally liable. You'd also look to see if there was proper training and supervision of the agency's personnel. It's a mitigating factor. The reasonableness of the explanation for noncompliance, the helpfulness of the agency to the requester, the existence of agency systems to track and retrieve public records. Those are all mitigating circumstances. The court would reduce the per diem penalty. The non-exclusive aggravating factors would be a delayed response by the agency, particularly when it was a time of essence, lack of strict compliance, lack of proper training, unreasonableness of any explanation for noncompliance, neglect, reckless, wanton, bad faith, intentional noncompliance, agency dishonesty, the public importance of the issue, any actual personal economic loss to the requester because you failed to provide it timely, and a penalty amount necessary to deter future misconduct has also been imposed by court. So all the aggravating factors there. There's a new 5-day response option, and this came out of the 2017 legislation. Request for clarification of a request must be coupled with an estimated response time. So it used to say, well, we need you to clarify this, but then we wouldn't put a new time. So now you say, we want you to clarify this, and based on that clarification, we can give you a new time estimate. So you need to provide that. If the requester does not respond to the agency's clarification request, and the entire request is unclear, an agency not further respond. So you can say, look, we are not going to respond further because it's unclear. We do not know what records you're requesting. Requests for all records and a bot request may be denied. Now, I'm not certain I really know what a bot is, but we all see that bot. You have to respond every now and then. It says, I'm not a robot, I'm a real person. So it's the automated bot response you would not have to respond to. You can say
It goes back to your original comment, though, if somebody requests all emails that have been produced by the hospital district, that's a all records type request. It can be denied at the first step.
Yes, or a clarification says specifically what topic do you want. So an agency can deny a request for all or substantially all records of an agency not relating to a particular topic. So if they say, I want every email that you've ever produced, you could probably deny that. Say, please identify the specific records you want or the topic, because otherwise it's too voluminous.
Right.
And you're really not being responsive. Charging for electronic records is now explicitly authorized as well. It used to be that you couldn't charge for sending an electronic copy back, and you can do that now. It can be including the cost related to the production, the file transfer, the storage, and the transmission, but again, not your staff time specifically.
Now, the production would include staff time, would it?
Now, it's more of the production in terms of cost related to actually the tape or the production cost, but not the staff time, not the staff person. But if there's a production cost to produce it. You can charge the actual cost incurred for providing electronic copies, the cost related to production, file transfer, storage. The other thing too is that's really hard when you have to come up with a policy because you have to identify what all those costs are. If an agency policy establishes that calculating the actual cost would be unduly burdensome, then the following default charges can be charged. 10 cents a page for records scanned into an electronic format. 5 cents for every 4 electronic files or attachments uploaded. 10 cents per gigabyte for transmitting the records electronically. You also have the option to charge a flat fee of up to $2 as an alternative to actual or default cost if the agency reasonably estimates and documents the cost are equal to more than $2. So we're trying to figure out a simpler way to keep track of the costs. So effective July 23, 2017, all agencies have to now track and log the identity of the requester. It used to be that you did it anyway, but now the legislature said, I want you to do that specifically, because they want to get a handle on how many records requests were coming down. And they kept hearing anecdotally that it's taking lots of staff and lots of time, and we can't focus on our mission. And so they said, okay, we're going to require you to keep track of this. The date and the text of the request, the description of the records produced, description of the records redacted or withheld, and the date of the final disposition. So now you're collecting this information so that you can go back to the legislature and say, this is how many requests we got, this is the type of requests we got, this is how long it took.
Is this information accessible under the PRA?
Sure.
In other words, if a person makes a request, that may not be private.
It's not private. Once a public records requester requests something, it's no longer private.
Okay.
That becomes a public record. Yeah. Agencies with $100,000 or more in annual staff and legal costs associated with it, they're required to track 17 additional metrics and submit an annual report to the Joint Legislative Audit and Review Committee. Fortunately, you're not there, and I hope you'll never get there that you would have to do that. But that requires a whole bunch of collection of data. The model rules provide information and suggested best practices. 2017, the legislature amended the PR to say local public agencies should consult the model rules. So again, they're not binding, but you should consult those. The model rules are put out by the Attorney General's office. Proposed updates are supposed to come out. They confirm the public is entitled to that. They provide a model policy for handling requests. They address relevant court rulings and changes. So Attorney General's office is trying to provide greater assistance to public agencies. And I have some checklists for you, and you have those for you. And I'm not going to go through those in detail, but they outline what MRSC, National Research Service Center, has given you. They've given you a checklist that you can follow, and so you each have one of those. And they've also given you practice tips for local government success, and you've got that, how to implement it. That's a 2-page document. And then they gave you practice tips on electronic records for the PRA and records retention. If you have trouble sleeping tonight, just start going through all these checklists. Instead of counting sheep, you can count all the checklists. And then the do's and don'ts for local government success. So a lot of good checklist information here that you can go through in great detail. Yes?
I believe MRSC said that you can make a verbal request for
Yes,
a
you
record,
can.
and that is as good as a written request.
I don't know if it's as good because it's always not as clear, but it is valid as a public records request. You're supposed to acknowledge it as a public records request, even though it's verbal. You're supposed to clarify it if you don't understand it. You're supposed to respond within 5 days.
Now, some organizations, and we may be one of them, have a special form that they require to make a PRA request. But as I understand it, you don't have to use that form.
Do not.
You can call them up on the phone, and they should log it in, and it becomes a request.
You're correct, Commissioner Pollard. You could just simply put out handwritten note, I want this or that. What we're trying to do by creating forms is to assist the requester so that we know when you requested it, what you requested, what the identifiable public record is, so that we could clarify it. To the fullest extent possible, we're trying to help the requester pursuant to the statute. So you're right, you can't make people use forms. Oral requests are just as good, handwritten requests are just as good. We're going to jump to, here's recommended resources that you've got available to you as well. Here's my last caution from Abraham Lincoln. Don't believe everything you read on the internet just because there's a picture with a quote next to it. So be cautious about doing your own research sometimes when you deal with public records, because it may not always be completely accurate. So questions, answers about that so far? Good, because now we're going to see the official version of the Attorney General's Office on Public Records Act. And I almost called you Vanna. Valerie, would you turn over a letter for me?
Oh, are we in trouble
It's
now?
people, places, and time.
Yeah.
Okay.
So here, this is the official Public Records Act training prepared by the Washington State Attorney General's Office. They are working on another update. They are going to produce that, I'm told, sometime this year. I don't know that it'll happen. And you can see this little comment and quote here the bubble. Thanks everyone for helping me search for that requested record. Literally back in 1972, this is what you did. You went through boxes and card files looking for public records. It was really horrific trying to find it. And then penalties were still the same if you didn't find it.
That's not that long ago, because when I ran 6 years ago, I got all the stuff from the hospital. It was that thick, I had to pay for it,
Yeah.
but somebody had to go find it all, and I went into Seattle and I picked it up. So somebody had to pull all those papers out.
Yep. A lot of organizations, unfortunately, now have public records officers. It's a full-time position. Sometimes they have more than one staff. One of my clients is the Association of Washington Cities, and I represent their risk pool, and they hired a person last year because they had so many records requests. They have a full-time public records officer. And I'm sure large organizations, the City of Seattle, they have numerous individuals that just work full-time on this.
And it's a big building, they have lots of records in it.
So, open government laws like the Public Records Act are often called transparency laws or sunshine laws. And in fact, there's a sunshine committee that looks at exceptions and exemptions. It's a legislatively created body. And this came out of a case in the United States Supreme Court. Justice Louis Brandeis, he once famously said, sunlight is the best disinfectant. So that's where that came from. And I guess from the medical perspective, that might be partly true. But now, let us begin transparency and sunshine. So the purpose is identified in the statute, and again, it's cited there for you. You can go look it up. The preamble says the people do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so they may retain control over the instruments they have created. So that's kind of like our founding message in 1972 from the legislature. It's kind of like your U.S. Constitution when we talked about the preamble, when we talked about unalienable rights and freedoms. So the PRA, passed in 1972, was an initiative, Initiative 276, and it was formerly RCW 4217. It has been modified, so if you have an old set of RCWs laying around, you need to get the newest ones. The recent amendments were in 2017. Touchstone, again, public records of government agencies are presumed open. So you start with a presumption. It's rebuttable, but you start with the presumption that everything is available and everything is open. Records or information can be withheld, but you have to show an exemption. You have to show a reason, a rationale. It applies to state government agencies, local government agencies, limited extent to the legislature. Now, there's a bill pending, and you all remember what happened last year. Judge Lanise in Thurston County heard a case that came forward that says we want all the records of the legislature. And the legislature says, no, those are exempt. Judge Lanise says, I think I'm going to rule that those should be made available. So they stayed. They stopped the lawsuit. They said, we'll stay it with the agreement that you'll work on it in the next session. They're working on it now, and I haven't tracked it very carefully yet, but I understand that there's numerous open public government organizations that are not happy with the proposed approach. So we're going to see. That'll be a very interesting approach as to what the governor will do. The governor vetoed the bill last year because he got, I think, the most ever emails and phone calls in the history of the governor's office. People were objecting and saying, how come everybody else in public agencies has to disclose and the legislature doesn't? Well, they were exempt. The only other body that's exempt are judges. The judicial branch does not have to disclose their information on how they came to a ruling. They have internal documents that they work on. Those are not discoverable. The PRA does not apply to court records or court files, records of certain volunteers or private organizations or persons. And there was a case, I think it was the Woodland Park Zoo, or one of the zoos, where the zoo was found to be a nonprofit, it was not a public agency, so it didn't apply. So it's only public agencies. Volunteers, records of certain volunteers are exempt from the definition of public record. They clarified that because they want volunteers. Records not otherwise required to be retained and are held by volunteers who don't serve in an administrative capacity, have not been appointed, and don't have a supervisory role. So they wanted volunteers to be able to volunteer without having people come in and ask for their information. Public record, again, we've already talked about that. Prepared, owned, used, retained by any state or local agency, regardless of the physical form or characteristics. So it can mean every other means of recording any form of communication. And so the RCW now goes into great detail. Words, pictures, sounds, symbols, combination thereof, papers, maps, magnetic, paper tapes, film, videos, discs, drums, diskettes. And just every time we turn around, there's another medium that we're using. Snapchat.
And they don't drop off the old ones like photostatting.
Yeah.
That's not-
Mimeographs, yeah. Yeah, you might not have any of that anymore, that's right. Public record is broadly defined. It can include, again, home computers or devices, or a non-agency email account or file, if it relates to the nature of your business. Text messages sent and received by a public employee in the employee's official capacity. This is a case out of Nissen versus Pierce County. That was the elected prosecutor in Pierce County was texting information to other deputy prosecuting attorneys, and some of it dealt with personnel matters. So Nissen sued, and in fact got all those records from the prosecutor's personal phone that he was using to text. So regardless of the public or private nature of the device used to create them, even if the employee uses a private cell phone, you have to track it, you have to maintain it, you have to retain it. Somehow you're supposed to produce that.
Now, is that only if it's not in your private life, just the part that's
Correct.
public?
Your private life is excluded.
Yeah.
But if it relates to the public agency or within the scope of the employment, if it's prepared, owned, used, or retained by a state or local agency. So it has to be within the scope or related to the public agency or the employment. Yeah, your private stuff is not going to come out. But it's still going to be a hassle because you're going to have to sort through all that.
Does that apply to the emails as well? If there are some
Emails?
businesses, but
Yeah.
they have to separate the private communications though,
You
right?
have to carve
It
it out.
cannot be, okay.
Yeah, and it deals with Facebook, Snapchat, text messages, tweets, all that. So, for a record to be used by an agency, it must bear a nexus with the agency's decision-making process. The record held by a third party without more is not a public record unless the agency uses it. That's the Facebook cases that have come out. So it applied to call and text logs at the phone service provider, which were not used by the agency. So if the county doesn't use them or have anything to do with them, it's not a public record. The on personal computers, personal email accounts, etc. The courts have come down and said, you're going to have to produce that. It was a local elected official's personal residence on a personal computer and a personal email account. The Court of Appeals said it has to be disclosed. The constitutions do not provide an individual a privacy interest in these public records. The state Supreme Court denied review, they upheld that. So privacy, PR agencies must appoint a public records officer. You have to have procedures, you have to have a process, provide fullest assistance as possible. You have to publish a fee schedule. If you don't publish one, you have to follow the statutory requirements. You have to maintain a list of laws that you believe are exempt or prohibit disclosure, and again, if you don't publish it, it's by statute. You have to make non-exempt records available for inspection and copying during customary business hours. And there are some bills that have been, I think, promoted this year that talk about what are customary business hours. That wasn't defined, so they're trying to clarify that. You're supposed to identify that on your website if you have a website.
Are we obliged to publicize that previous slide? And, yeah, and for that matter, even adopt an ordinance that sets forth our policy that complies with this?
Right, you would not have to adopt an ordinance because you don't have the authority to do it, but you could adopt it by resolution or create a policy for it. If you don't,
Are we obliged to?
Well, again, you're supposed to, but if you don't, there's no penalty
Okay.
because you have to comply with the statute. The new PRA procedures, the format, no official format is required. And that goes back to your comment again, Commissioner Pollard, is do you have to use my form? No, you don't. Agencies can recommend it and strongly encourage it and respond to folks, please use our form because it's most helpful for you and us. But you have to accept in-person requests made during normal office hours. A log, you have to keep the log now, we talked about that. And the ordinances, local agencies should consult the AGO model rules in developing the ordinance if you need to develop ordinance. And you can do that. Additional training, records officers have to receive training on electronic records now, data collection and reporting, and we talked about that previously, the $100,000 a year. Then you have to do the 17 data points. And new procedures for fees are authorized for electronic records. This is the schedule, effective July 23, 2017. The default includes paper copies, scanned copies, electronic. No fee for records routinely posted on the agency website. You have to provide an estimate of cost to the requester upon request. So if somebody submits a really large request and it's going to have a certain amount of fees, you have to give them that estimate so that they know. And if they decide they don't want to pay for it, then they don't get the records. Court action could be brought to challenge the agency's estimate of fees. Request for public records, identifiable public records again. You have to identify a document with sufficient clarity to allow the agency to locate them. The requesters can ask to inspect the records or request copies. So if they say, I just want to inspect them, I want to come to the hospital district and look at them, there's no charge. You don't charge them for that. Come look at them. A lot of organizations are putting everything on their websites now. So you go to the website page, you go to the website page, you just give them a link. Agencies can adopt procedures explaining where requests must be submitted and other procedures, but you have to accept the requests. Identifiable records. It's a request for all or substantially all records prepared, owned, used, retained by it is not a valid request any longer. So you just can't say, I want every record you ever created. Provided a request for all records regarding a particular topic or containing a particular key word or name shall not be considered. So I want every record that has the name Steve Daniel on it that's ever been produced. And you have to provide that. Generally, you need to identify the purpose of the request unless required by law. So the person doesn't have to really say why I'm requesting this. You can't ask them. You can't require that in order for them to get the records. Unless there's a need to limit the number of requests they make, you can't do that. There are some cases where there have been cases brought where a person was deemed to be a vexatious litigant, and they had to get the court's approval before they would allow them to ask for a public records request because they didn't think it was valid or appropriate.
Yeah, are we obliged to have an appeal procedure?
You should have an appeal process. And the appeal process can simply be the public records officer identifying it's going to be reviewed by the CEO. An agency may deny the bot request. We talked about that. It's one of a multiple requests that requested the agency within a 24-hour period. If the agency established that responding to multiple requests would cause excessive interference with other essential function of the agency, a bot request means a request for public records that the agency reasonably believes was automatically generated by a computer program or a script. You have to be smarter about bots than I am. Requesters must clarify a request when you ask for clarification, claim or review records when the records or installment is ready, comply with the agency's procedures, provide a deposit. So if you have a large cost or fee, you can say we want you to post 10%. Give us a 10% deposit, or we're not going to complete the rest of it. You pay for copies per the fee schedule, including copies for an installment. Requesters should also promptly communicate with the agency, including to voice any concerns. And remember, this is the Attorney General's official version, so they intended both for public agencies and requesters to view this. So they're really trying to encourage requesters to make the best effort they can to make sure they're getting the records they're requesting. So it seems to be balanced anyway. Your response 5 business days, we talked about that. You can provide fulfill the request within 5 days. You can seek clarification. You can send them to an internet address. You can seek clarification if it's not reasonably clear or it does not request an identifiable record. You're supposed to give them fullest assistance. Requester does not respond to the request for clarification. The agency can close the request. And it does happen from time to time. Estimate of time for further response. Again, if you get clarification, we need more time. It can require because you need search, or you need to prepare exemption logs, or you have other essential agency functions. We don't have the availability of staff and time to do this. We're short-staffed, we don't have as many staff. If you have a request from a very small public agency, a small fire district, port district, even a rural hospital district, you might not have the staff to respond. You can do it in installments. Agencies are encouraged to post commonly requested records on their website. You know, you get the same request over and over. Sometimes it's request for what's the salary of the CEO. Just put it on the website. Searches. You must conduct the adequate search. And there's suggestions there, the mechanics of searching it. You're supposed to obtain, segregate, and produce to the employer those public records that are responsive, personal accounts, files, devices. The employee may be required to submit an affidavit regarding his or her search. These are the efforts I undertook. This is the search names I used. This is how I did it. You prepare an affidavit declaration. You can submit that to the court and say, this is the efforts I undertook. Those are usually pretty well received. Records are all presumed open. Exemptions are narrowly construed. They have to be authorized in law. You can't make up your own exemptions. Agency must list the exemption and give a brief explanation. It used to be just said, here's the exemption. Say, attorney-client privilege communication. It's work product. And now you not only have to do that, you have to list an explanation. So instead of just listing the statute that says attorney-client, you have to put another sentence in there that says, this is an attorney-client information document. It is information requested from or received from our attorney. So now you have to give the narrative. That never made any sense to me, but that's what's required. It's called an objection log, and you have to put that in the objection log. The agency bears the burden or proof to justify that exemption. There's no general privacy. This is really interesting, is you have to go through this test, and it must be highly offensive to the reasonable person. And who is a reasonable person? Who's the ordinary reasonable person? Who is that? It's you. Yeah, it's you. You're all ordinary reasonable people. It has to be that, and it has to be not of legitimate concern to the public. So not only does it have to be highly offensive, it also has to not be of legitimate concern. So that's how you get all these public records requests for information about, I want to see the investigation, I want to see the personnel file, I want to see this. And those usually come from newspapers. This means that if information does not satisfy both the factors, it cannot be withheld as private information under the statute. Electronic records and production disclosure. Remember the definition, public record includes electronic records, and that's the new requirements that we comply with. Electronic records and production disclosure, these are the basics. These are new because of the bot request and the fees for copies. Electronic records production disclosure resources. Here's all the resources again. It's MRSC, it's the Secretary of State. They put out exemptions and they'll put out information. And you can go to any of these websites and get lots of information. Disclosure redaction mechanics. We can redact these, and there are software programs now that permit standard redactions, and they give you some information. It used to be by hand. You took black magic markers, you struck stuff out. Now you've got programs that can do that. Electronic record production, disclosure production mechanics. They show you how they can be produced. Posting them on agency's website, delivering copies. Updating and improving technology. This is where the future is going. These portals, posting the commonly requested information. And again, there's local government grants and there's Attorney General resources and funds available to assist you. These are the penalties, and again, this is the concern, is that they are enforced by courts for claims listed in the PRA. They can impose civil penalties, and you don't have to prove damage. You don't have to say, because you didn't give this to me, I couldn't go forward with development of my land, or I couldn't pursue a civil litigation. You don't have to show an actual damage. You can just say, I didn't get it in the timely manner as required, therefore I'm entitled to civil damages. Court will consider the factors, and they can award prevailing requesters attorney fees and costs. So the actual civil damage may be rather small, but then you get the attorney fees and cost bill, and it's $100,000. The court will look to make sure that those are reasonable attorney fees, but potentially could be.
Well, and then there's the $100 a day.
And then there's up to $100 per day per record.
Yeah.
Correct. So here, we've talked about the mitigating factors and aggravating factors before, so I won't go through there, pretty much the same. And here's all the aggravating ones that the court would look at. Here's penalties outside the PRA. There can be criminal liability for willful destruction or alteration. So there's no criminal violation if you didn't produce it timely, or you didn't find a record, or you misplaced a record, and that happens. But there would be a criminal penalty if there was a destruction, and that's covered under the RCW, and it's identified there. If an employee intentionally conceals a record that must be disclosed, that also could have complications and criminal. Training, Open Government Trainings Act, public records officers, statewide and local government officials take the training sooner than July 1. Refresher training is supposed to occur no later than every 4 years. So you've had the training now, you're good for 4 years. Your vaccination, you were inoculated this evening, you're good for 4 years. When we update your tetanus shots, we'll get this. All right. Other training resources where you folks can go, and that's all listed there. It's the AGO Open Government Resource Manual. That's what it looks like. It's the Washington State Sunshine Laws. It says 2016 there. That's the last one that got out. They're updating that. Here's just some real quick risk management tips. Establish a culture of compliance. Review your procedures. Train staff. Review your resources. Review the penalties. What you're doing like that, consult the agency's legal counsel. You're doing all those things. And on behalf of the Washington State Attorney General's office, we thank you.
A question, it was mentioned, I think, in one of these pages, but what is the relationship of the PRA to the records retention?
Well, the Records Retention Act is somewhat separate, but they want you to be trained in that as well. So how long you're going to retain that. So it's really critical that if somebody requests a record and they say, well, we've no longer retained that, you have to show you complied with the state's requirements for how long you have to retain records.
Are we complying with the Records Retention Act?
Yes.
Yes. Yes. Hospitals are really good about retaining records for the period of time. Some of them have to be retained, I think, forever. There might be some, but some of them are like long periods of time.
Death certificates.
Original signatures might have to be retained forever.
I've got a question. It
Yes.
says, PRA doesn't apply for records. That's not true.
I was going to ask that.
Well, unless they're
I
public
get them all
records.
the time, PRAs.
Yeah, but the court records, some of them do apply, but not the judges' records, the actual court records of the judges.
Oh, I mean, his notes or?
Correct.
Okay. Okay, because all of the documents.
All the documents that are in that.
In the file that are
Correct.
related to the case.
Yeah, unless they were sealed, then you have to
Unless
request
they're
it to be
sealed,
unsealed.
unless it's a child. Right.
Yeah.
So, with that, they're already in order. So, I'm going to present, thanks to Valerie, look at these beautiful certificate of completion. This is President Darrell Norris, and I have signed that document that says that you have completed that. And so if anybody questions whether or not you've attended that, you have a certificate to show them.
This plus $1, but you've got a copy.
That's true. And on behalf of the Attorney General's office, this is a certificate of training that identifies President Darrell Norris, Secretary Spikers, Vice President Emma Herron, Commissioner Young, and Commissioner Pollard. And you have to sign that one. It says that you've completed the training.
Do we,
No, I don't want it back. Those are yours. You get to keep them. But they're not nearly as nice as the ones that Valerie put together.
Right. Thank you, Valerie.
Now, for the folks that want extra credit,
Continuing ed?
I'm going to give you the case law update because I went to training last week. And these are the cases that came out in 2018 and the first start of 2019 already.
A lot of them.
Yeah.
I can hardly wait to read this.
Wow.
It'll be the next work study session.
So in 2018, there were 33 decisions, both published and unpublished. An unpublished decision cannot be used for precedential value, but the court gives an opinion. They just say you can't use it for precedent. And there's already been 2 now in 2019. this presenter is Morgan Damerow with the Attorney General's Office, and this was through MRSC. It was a webinar. I think it might have been the one, Steve, that you and I talked about, so I actually attended this online. And it includes copies or summaries of 18 of the cases, and you can go through and read those. They're a short little synopsis of what they are. They deal with everything from inmates who had requested former police officers on polygraph results, inmate phone calls, videos taken by cities, union member requests, Facebook issues. I page numbered these just in case you want to know. And there is one on page 13. Page 13 is West versus Puyallup. That was a Facebook case that came out. West made a PRA request for copies of the post to a commissioner's personal Facebook.
Where's that?
That's on page 13. If you look down the lower right-hand corner,
I gotta get there.
I've hand-printed some some page numbers for you.
West versus Puyallup.
West versus Puyallup. Arthur West is the litigant here who goes around and makes lots of requests of cities and courts.
No,
Pretty well
like
known,
that.
yes. And what they ruled is that a public official's post on a personal Facebook can constitute agency public record subject to disclosure if the posts relate to the conduct of government and are prepared with a public official's scope of employment, but not their private stuff. They don't get pictures from the hockey games, but they can if you're talking about affiliation. Yes,
So,
Commissioner.
could you define conduct of government? Now, what if
Yeah.
a person on a personal computer writes an opinion about something government is doing? That's not the conduct of government as such.
If it's related to the scope of your position or the agency of which you are associated with, it could be. And again, we wouldn't know until it got to the Court of Appeals. And they would make a decision. They would figure out that definition. So you really never know. And then I just want you to turn to one other to see how impactful this can be. Go to page 16. This is called Zink versus City of Mesa. Mesa's a small
California.
area. 16. No, Mesa, Washington.
Oh, Mesa.
There is a Mesa, Washington. It's over by Colotus.
Oh,
You know what that is?
no.
No?
I don't know.
It's over
Never.
by
I know
Richmond,
Arizona,
Pasco.
Mesa.
Okay.
Really?
Near Washington.
Rural.
Yeah,
Very,
you
very.
don't know where Washington is either? Near Starbuck. There's a little town there called Starbuck as well, and Dodge. So anyway, these little tiny communities.
It's a city, huh?
Yes, there was a case that was brought by Zink, and it involved 33 violations and 22,000 penalty days. The trial court set the daily penalty rate for each request, and they included a variable reduced rate for certain requests. The trial court determined that the total preliminary penalty award was excessive due to the City of Mesa's small size and limited resources. The preliminary award was approximately 2 times the city's annual general fund.
Oh, my goodness.
So they're going to have to disincorporate. They're going to have to declare bankruptcy and go out of business. So what the trial court then did is reduce the penalty by 50%. And the court says you can do that. You can take into account the resources of the public agency. Otherwise, they would have gone out of business. So that's what it can entail if you don't respond. So anyway, again, if you want to learn more, you can read more about that. All right, any other questions? I was shooting for 8:15 because I thought Commissioner Spikers would have to leave at 8:15. I'm at 8:14.
So question,
Yes.
an individual can request, you said nonprofits are exempt, only public agencies. Can a
Must be
public
public agency.
can request something from the nonprofit for information?
The public requested from a nonprofit, but
But
unless
you
that
don't
nonprofit
provide
is a public agency or has some connection with a public agency, you don't have to disclose that.
Okay.
There are some rules for nonprofits, though, that include some disclosure.
If you're a member of a nonprofit, if you're a member, you can get certain financial information, you can get certain other information if you're a member of the nonprofit.
Right.
But if you're not, you can exclude that and say no.
Yeah. Then the question is, how do you define member? Is it this, are you on the board? Are
No.
you
No,
just a
if you're a
citizen?
member of, say, a retirement community,
HOA,
or in my
retirement
case,
community.
we have a home in Desert Air. If you're a member of that association, you can obtain records.
Okay.
And usually, the bylaws would identify the eligible members. You are a member if you meet these following requirements from the bylaws and the articles.
Yeah, and you can request for it.
Yeah, so, there are some organizations who, have been deemed to be quasi-public agencies. For instance, the Association of Washington Cities is not a public agency, but it's deemed to be a quasi-public agency because it receives all its funds from the cities. That's how it operates.
Same thing with municipal league, I suppose.
I suspect from the Association of Washington Counties, maybe municipal leagues, I suspect some other league.
Well, like, for example, Snoqualmie Sister Cities Association, they're
Yeah.
receiving tax dollars as well from the public. Is that if you want to get their,
You could
public
request it from the city, but if that is a nonprofit organization, they might not be a quasi-judicial or a quasi-public agency.
Nice.
Washington State Hospital Association would probably be a quasi.
Potentially,
Foundation.
but again, they're a nonprofit and
Yeah.
they're a separate corporation. Same with the collaborative, you know. The collaborative right now, I've advised them, is not a public agency. You don't have to comply with that requirement at this point. But again, like I said, Yogi Berra, the future ain't like what it used to be. We don't know what's gonna happen.
Yeah.
There's a lot of Court of Appeals decisions each year that come out on this. Well, thank you for your time
Thank
and
you.
patience
Thank you so
sitting through all
much.
this.
This is great.
Okay, do we have any public comment?
Well,
Well,
this
but
is the
this is
second.
the second meeting.
We can have more public comment.
Yes. Not hearing any, we will move on to upcoming board meetings. Regular meeting will be Thursday, March 14th, 2019, 6:30, North-South Conference Room. Our work study will be Wednesday, March 27th, 2019, 6:30, in the North-South Conference Room, which is here. Do I have a motion to adjourn?
Motion to adjourn.
Is there any discussion? Hearing none, we go to a vote. All those in favor say aye.
Aye.
Opposed? We're dismissed, 8:13.